Welcome everyone to this webinar. My name is Hakeem Crampton, the Government Relations Liaison for Citizens for Prison Reform. This is one among a number of series of webinars for the Participatory Defense First Hub. It is a phenomenal program in the Ingham County, Clinton, and Eaton County areas in which we support families who are experiencing court-involved processes. And today we are joined by a special guest, Ms. Bar Pash, who will be talking to us about the Michigan court system. She has a phenomenal experience and background working throughout the law from different law firms, from district court to the judicial court system to the Michigan Supreme Court. She just has a phenomenal background. So thank you, Barb, for joining us.
You're welcome. Thanks for having me.
Absolutely. So let's talk about the experience, the court process experience. Many families who either themselves are arrested and accused of a crime or have a loved one who is arrested and accused of a crime. If it's their first time, they really don't understand and know the processes that are involved with going to court and facing potential consequences for the accusations. So let's briefly talk about it. So say, for example, a person is accused of a crime and they are arrested and they're taken into custody. What happens next for them?
So the first thing that's going to happen if they're arrested, taken to jail, they will be arraigned. And depending on what time they get arrested, it will depend. And if it's the weekend or a holiday weekend, sometimes they're arraigned within 24 hours. Usually the same day they get arrested, by the next day they'll be arraigned. Usually it's been done by video with the magistrate. Used to be done with them coming over in person, but everything changed after COVID. So they should be arraigned within 24 hours. Sometimes it can be a little bit longer.
And someone who's in this position, according to the Michigan Indigent Defense Commission, they are afforded the opportunity for counsel at first appearance. Is that correct?
Absolutely. The Public Defender's Office has what's called a first appearance attorney at all arraignments to help the person being charged through the arraignment process. They'll talk to them about what their rights are and what's going to happen at the time of the arraignment, explain just how the magistrate or the hearing officer is going to tell them what they're being charged with, what the possible penalties are. We'll set a bond and any bond conditions that are necessary at that point.
And at this stage, there is no evidence presented to the judge to convince them that this person is either innocent or guilty. Is that correct?
That's correct. The arraignment is just simply to advise you of what your charges are and what the possible penalties are and setting a bond.
Okay, and then a person therefore moves to the next level of the court process, which would consist of what?
So if it's a misdemeanor charge, they will be set for a pretrial conference. Pretrial conference is simply an opportunity for either the defendant or his attorney, the defense counsel, to meet with the prosecutor to see if there's any way to resolve this case. A lot of times a plea offer will be offered at that time. If they can't resolve, it'll either be moved to a second pretrial, a final pretrial, or they could even set it for a jury selection.
Okay, so even before we get to a jury selection, if it goes that far, there's what's called a preliminary hearing. What does that consist of and when does that occur?
On a misdemeanor, it would be the pretrial conference. That's the preliminary hearing. On a felony, at arraignment time, they'll be given 2 dates. The probable cause conference, also referred to as the preliminary exam conference. So you'll hear some people call it a PCC, other people will call it a PEC, but it's basically like the felonies version of a pretrial conference. It's basically where the attorneys will meet, they'll talk. A lot of times the attorneys do not have all the discovery, which is the police report, dash cam video, body cam video, anything that the police have through the prosecutor, they have to provide that to the defense. So if they don't have the discovery, they will ask for a second probable cause conference to be set. On felonies, you have to have, at the time of arraignment, you're given a probable cause conference date and a preliminary exam date, and those are within 21 days. By law, you have a right to have both of those hearings within 21 days. Now, most times that doesn't happen in 21 days, and that's because the attorney doesn't have time, especially depending on how big the case is. A lot of time the discovery's very large, so they haven't had a chance to either get all the discovery or to review all the discovery. And as much as you want your right to a speedy trial and get things done, it's usually in your best interest for your attorney to have all of the evidence so that they can prepare for a preliminary exam hearing, which is district court's version of a trial. It's like I call it a mini trial, because the prosecution is trying to they have to prove to the court that there's at least some evidence that the defendant committed the crime and that the felony was committed. So there's elements of every crime, and the prosecution has to show at least, some element of each of the elements of the crime at that time before it can get bound over to circuit court.
Okay. So that's some great information. Let's back up just a little bit and let's talk about what is the difference between a felony and a misdemeanor? What are the potential consequences?
Okay, a misdemeanor is usually you're looking at 90-day or 93-day misdemeanors, or even up to a year. Anything that's over a year in custody can be will be charged as a felony. So it really depends on what the maximum amount of jail is. And the one thing I really want to stress, because if you're not familiar with the court system and a judge starts talking to you about you're being charged with a felony, the maximum possible penalties is 10 years in jail. I would imagine as a person, the minute I hear 10 years, I won't hear anything else. And that's just because that's a shock to your system. And you have to understand that they're telling you the maximum penalties allowed by law. That doesn't, even with a misdemeanor, when they say 93 days in jail, that doesn't mean you're going to jail for 93 days. You may not serve any time in jail other than the time that you've been arrested. But that's the maximum allowed by law. So that's what you have to try to remember they're going to be trying to offer a plea bargain. The case could be dismissed if the victim's not on board. It could be dismissed because it's in the wrong venue. There's many reasons why it could be dismissed. If it's dismissed because it's in the wrong venue, it's usually recharged in the proper venue.
Okay, that's great information. Now, assuming that things are progressing in the courts, particularly with the felony, for example, we've had our probable cause hearing or preliminary hearing, and it's been bound over to the next level. What is the next level? What happens next?
Okay, when it's bound over to circuit court, they're going to give you most of the time that if you have an attorney, if you don't have an attorney, they're going to schedule you for a circuit court arraignment. It's going to be the first date you get at circuit court. If you are represented by counsel, they usually, if they give you an arraignment date, the arraignment is not usually held, because basically it's going to be the same thing that was done at the district court level at arraignment, just advising you of what your rights are, what the possible penalties are, what you're being charged with, and setting a bond. So usually the arraignment doesn't happen, and then they would go to a pretrial again, which would be another chance for the prosecutor and your attorney to try to resolve this matter, short of going to a full-blown trial at circuit court. If it can't be resolved, then you go to trial. You'd have a jury selection, they would pick jurors, and then you'd go to a trial at circuit court where they would present all of their witnesses, the testimony, the evidence, all of that.
So when you say if it's not resolved, does that mean that's an opportunity for what's called a plea bargain discussion?
Yes, that's usually happened at the pretrial level where the attorney and the prosecutor will meet. The prosecutor will say, this is what I'm willing to do, and the defense attorney will say, well, this is what we want, and it kind of goes back and forth. And if you just can't come to a meeting of the minds between the prosecutor and the defense counsel, then you end up going to trial. Some prosecutors on some cases will just simply say, there's no offer. We're going to trial on the original charge.
So during that opportunity for a plea bargain, would that be an opportunity for a person that may be facing a felony to plea bargain it down to a misdemeanor?
Typically, that's done at the district court level. Very rarely is it bound over to circuit court and then sent back to the district court, but it is a possibility.
Okay, okay. All right. So assuming, and unfortunately, that we're going to have to go to trial, what should a person really expect at the trial level? What is occurring? What rights is available to me? For example, say I was the defendant. What can I expect?
Well, that's a great question. They they'll set you a trial date, but you have to understand at the circuit court level, they'll have several cases scheduled for trial that day. So as you get closer, the oldest case will go first. And a lot of times the day of the trial, cases are resolved just because they can't take 8 cases to trial on the same day. So a lot of times your case will be number one on the docket, and trial starts with picking the jury. So sometimes you'll be scheduled for trial, but you won't be number one on the docket, and it'll come right down to the very last minute, which is very nerve-wracking to not know if you're going to go before, your case is going to be called that day. So just to be, aware that you may not go to trial the first day your case is scheduled.
What is the strategy for the defense in picking a jury? What would be their strategy? How would they know what type of jurors they want on their case, et cetera?
I think it's all kind of a gut feeling, experience from the attorneys on, what they're used to, depending on what the charge is. If say it's an assault and battery charge, the attorneys are going to be asking the potential jurors if they have ever been involved or charged with a crime, if they have any loved ones or family members, or even if themselves have been a victim of assault and battery or domestic violence or whatever the case might be. They don't want people that come in with preconceived feelings about what that charge is. So say somebody has a sister who was involved in a domestic violence with her ex-partner, and it was very traumatic for the family. They're going to immediately have those feelings, and the defense is not going to want, or the prosecution's not going to want that witness or that juror. The defense would want that juror because they would know, what's going on. So, or maybe that was vice versa. I think I said that backwards. Defense would not want somebody who has the feeling that feels very strongly against somebody who would commit an assault or a domestic violence, and the prosecution would want them.
Yeah.
So
Yeah.
and like I said, a lot of it's a gut feeling and just experience going through it. Typically what happens after the trial is the judge will ask the jurors if they're willing to speak with the attorneys. And if they are, the attorneys can go in and ask them, what were whoever is on the, I don't want to say losing side, but the side that didn't, either the prosecution, if he gets a guilty plea, or the defense, if he gets a not guilty plea, will say, what is it that convinced you, or what is it that was missing that, you didn't get the verdict that you wanted. So that really helps attorneys for future reference and future cases know. Even in the case of an appeal, if they're going to appeal, if the jurors will tell them what they're missing, what they missed, then they can make sure they hit on that if they get the appeal and they can go back, then they'll know what to really focus on.
Okay. So now we've got a jury selected, we've got the jury seated, and it looks like we're going to go to trial. What does that look like?
Well, I'm sure for the defendant, it's very, very intimidating because you're looking at these people who basically have your future in their hands, but they are just people. And at the end of the day, they're going to try to do what's best. You're going to go into the courtroom. The jury will be called in and sworn in. They start with like jury instructions. The judge will read a bunch of jury instructions and explain it to them. And then when it comes time that all the formalities are done with the jury, then the prosecution will call their first witness. The prosecution goes first, then the defense goes, and then the prosecution goes again. So you get your first witness on the stand, they have direct examination of your witness. That's the prosecutor. So they're going to ask all the questions of the witness. The defendant just has to sit there and not say a word. The defense attorney may object to some questions, and when that happens, just like everything stops, and the defense attorney can explain his objection, the prosecution will then respond to that objection, and then the judge will rule on the objection, and then they'll go on. So when direct exam's over and the prosecution says, you know, I've asked all my question of this witness, then the defense attorney gets up and will ask questions of that witness. When the defense is done with cross-exam, the prosecution can then do redirect. And the reason the prosecution gets 2 shots or 2 bites at the apple is because it's their duty. Defense can walk in, not call one witness, not present one exhibit, nothing. And if the prosecution doesn't prove their case, then that's a not guilty verdict. So it's the prosecution's responsibility to prove the case. So they get the first bite and the last bite of the apple.
Okay. And this goes back and forth with the multitude of witnesses. And then I assume that the prosecution will do what's called rest their case, in which they feel that they've convinced the jury that the person who is on trial is guilty. And then the defense gets a chance to argue that they're not guilty. And then what happens? We wait for the jury to come back with a decision.
Yeah, so after the prosecution rests, then the defense has an opportunity to call witnesses, call the defendant if they so choose. It's very rare that the defendant actually takes the stand. And the reason for that is while you and your attorney can ask the right questions, the prosecution might ask a question that opens the door for other questioning of whatever you respond to. So you'll hear a lot, somebody will say, well, that opened the door, so we can question that. And typically what happens in direct, you can't go outside of that kind of testimony in cross. So you just kind of go back and forth, and once all of the testimony is done, defense rests, then they do what's called closing arguments. And that's basically where you just kind of, the attorneys will reiterate to the jurors, like recap everything that was said and testified, and they'll really hit on their bullet points of what's important to prove their case or to disprove the case. Then it goes to the jury. So then the jury goes back, goes into the jury room. They're sequestered back there, and the first thing they need to do is pick a foreman. A lot of times the judge will instruct the jury, just go back there and do a initial poll on where everybody's at. You might be surprised that more of you are on one side than the other, and then you know like where you need to go. So I've been a juror before, so I know personally that it can take a very short period of time, or it can take days. So it's just it just depends on the jurors that are sitting and what their feelings are and what they think, and hopefully you can get a verdict so you don't get a hung jury where where they could actually prosecute you again and start over.
And so a hung jury essentially means that all of the jurors weren't convinced whether of guilt or innocence. Is that correct?
Correct. You can have one holdout that will not go along with everybody else, and no matter how long they sit and talk about it, they just cannot come up with a unanimous verdict. So a lot of times they'll come out and say to the judge, we just can't get there, and the judge will, grant that it's, a hung jury. Or the judge will say, go back and try again, and encourages them. That happens quite often because sometimes people will think, well, we just can't get there. But when the judge says, well, just go back there and keep talking and try, a lot of times they'll get there.
And
And that
so,
that kind of goes back to picking your jury. You don't want somebody that says, say your trial's on Friday and it's 4:30 and you've been deliberating for hours and hours and you've got plans on Friday night. You want to see your kid play high school football and you just want to get out of there and you're the one holdout. You want somebody who's going to say, I don't care. I'm staying here as long as I have to because, somebody's life is I'm holding in my hand. So that's kind of back to the jury selection on how you want to pick your people.
say for example, I've been very fortunate and I was found not guilty. That means that I get to walk out of the courtroom, and can the prosecution follow back up with more charges, or what happens if I'm found not guilty?
Once you're found not guilty, they can't come back and try it again. I think they call that double jeopardy. I'm not sure, but they can't do that. If anything came out during testimony that might be new charges, they could possibly do that because sometimes things will come in. Attorneys try to keep that out of it, that could either have a witness charged with a crime or the defendant charged with a new crime. So, but typically, if you're found not guilty, you're done. But the only thing to really think about at that point is when you were arrested, your fingerprints were taken. Your fingerprints drive your criminal history. So your criminal record will still have the charge. There's three segments to your criminal history, and that's the charge, the prosecution level, and then the disposition of the case. So if somebody were to do a background check on you and you were found not guilty, it will say that, but it'll still be on your record. So a lot of times at that point, you want to, depending if you've got a completely clear record and you don't want anything on your record, or even if it's just a charge that you don't want potential employers to see, you may have to have an attorney do a motion for destruction of the biometric data, which are your fingerprints. So you want to get that off of there, and you usually have to do that through a motion.
And that's usually held at the Michigan State Police Department. Is that correct? That's who holds the records?
They do hold the records, yes. But it would be done through the same court. The motion would be done through the same court where you were at for your trial and your charge.
All right. So if that doesn't happen and I am found guilty of a charge, what should I expect next to follow?
Well, the next thing that's going to follow is the judge is going to want somebody to meet with you one-on-one and get a lot of information. If your charge has anything to do with drugs or alcohol, or there's an underlying drug or alcohol situation that, it could be like drug seeking behavior that the crime was just breaking into houses, but it was driven by, an addiction kind of. They're going to want to look at what your alcohol and drug use is, and they do that with they call it an alcohol assessment. There's different companies that do that, so they'll have you do an alcohol assessment or a substance abuse assessment, I think is what the official name is, and then the judge uses that to help guide him through the sentencing. And it's helpful because the judge could look at it and say, this person just really needs treatment. So rather than sending them to prison, I'm going to put them on so many years of probation, but I'm also going to have them go to rehab. Originally do like inpatient rehab, and then when they get out, they can do some extensive outpatient treatment, and then stay on probation for a couple of years rather than going to prison. So that's kind of what the assessment is for, is to help the judge determine what's best for that person.
And I assume that's called the pre-sentence investigation report?
Yeah, at circuit court, they do a pre-sentence investigation report. At And that's kind of done through the MDOC, because typically at that point you're looking at prison time. That doesn't mean you're going to go to prison, but what they do at the pre-sentence investigation report is they're looking to see what your numbers are. And I don't know a lot about this, but it's basically a numbered system, and they look at your criminal history, your ties to the community, your family life, all that kind of stuff to come up with these different numbers. And when you get to a certain number, that will drive like whether you go to prison or not. So the more offenses you have, the more your numbers go up. And yeah, so but hopefully you can get to the point where you can just do probation and not have to go to prison.
Yeah. Now, I've also seen where a person has been found guilty. They have a scheduled sentencing date, and they're doing the, background information, the pre-sentence investigation, et cetera. Is there an opportunity or a window for my defense attorney to file a motion to set aside the verdict, to request a new trial? Is there something that can take place even before the sentencing occurs?
I'm not 100% sure on that. I know once they're sentenced, they have a right to appeal. So I know at one point you can do a motion to withdraw, like if you enter a plea, you can do a motion to withdraw your plea. But, and then after you're sentenced, you have a right to an appeal. And that has to be done within so many days. And if you can't afford an attorney, or if you have a public defender, they will appoint a public defender for you to go through the appeal process.
Yeah, and I believe that public defender will come from the state office of the state appellate defender's office, what's called SADO, if I'm not mistaken. That case will then be handed to them once you file your appeal. Then those documents will be sent to the state appellate defender's office, who will then evaluate whether or not there's what they call merit. Is that correct?
That is correct.
All right. All right. And then I assume that once a person gets sentenced, if they are sentenced to incarceration, their family will then have to deal with the next level of supporting them and finding out what the next steps are for them while they're incarcerated, and what treatment and services they'll be needing while they're there, and hoping for them to rejoin the family.
Absolutely. If they're being held in county jail, which usually they are until they, once they've been sentenced, they would go to county jail. And each day you serve once you're sentenced, or even prior to that, if you're in jail and on that charge, you're accumulating days. So say it takes, I mean, COVID changed everything, but after COVID, courts just like basically shut down until they figured all the Zoom stuff out and could go on. So a lot of people during COVID time were in jail for a year, couple years, waiting to go to trial. All of that time you're in jail is time served. So say you get 5 years in prison, but you've been in county jail for 2 years. Those days are going to come off your sentence. So you would only be serving 3 years in prison rather than the whole 5.
All right. Well, I'm not sure what else might need to be covered in discussing the criminal court process, with the court system, with trial, pre-trial, post-conviction, et cetera. But if there's anything else you could think of that would be beneficial to our viewers, please share it with us.
You know, the one thing I kind of like to add is bond. Sometimes people, they don't really know when the person, when the magistrate says, you have a $25,000 cash surety bond, or a 50,000 or 100,000, whatever it is. Cash surety basically means you can either pay that in cash, the full 25,000. You can get a bondsman who will charge you a percentage of that. But it's important to know, if you do get a bondsman, say you get $25,000 cash or surety, and you go to a bondsman, they're going to want $2,500. You don't get that money back. That's their fee. But if you pay your $25,000 cash, and as long as the person being charged shows up to every court date, once they are sentenced, that bond will be returned to whoever posted it. There's also that sometimes they'll say cash surety or 10%. When they say cash surety 10%, that means you can post the 10%. And so if you pay the $2,500 when after the case is over, you get back everything but 10% of that bond. So it's very confusing that when they start throwing things around, if you haven't been in the criminal justice system to understand, the surety thing, and then you think you pay that and then you get it back if the person appears and everything, and then you say, well, how do I get my money back? And they're like, usually the courts will just say, go see the bondsman, and the bondsman will say, oh no, that was for us because we had to ensure your appearance at court. So, there's also on some felonies, they will issue a no bond hold. And that just means you're not entitled to get out at all. And then at that point, you would have to ask your attorney later on down the road to readdress bond. And they're going to be looking at like your ties to the community, if you have a job, if you have family here, how long you've lived here, what the chances are that you're not going to flee and run. So that's the other thing. But that's really, besides that, they can also issue no contact orders on domestic violence, some assault cases. They're going to issue a no contact order. That means the person being charged cannot have any contact with the alleged victim. And that's really important to know because a lot of times the alleged victim will say, but I want to talk to you. Even if they're the alleged victim on the case, if you have contact with them, you're in violation of your no contact order and you will go to jail once it's determined, found out. There's no doubt about that. They will send you to jail for violating that. The alleged victim, even if she or he contacts you, there's no recourse to them. So just be aware that even if that alleged victim or the person that you're not to have any contact with contacts you, that's still a violation on your part, not theirs. So you want to be really careful, and that includes direct contact, indirect contact, say through email, Facebook, third-party contact, having somebody contact on your behalf. Your attorney can ask the judge, say that you're not allowed to go back to your own home because the alleged victim is somebody you resided with. You can ask for one time to go back to the house with police presence to get personal belongings out of the house. So, and you either have to wait for that no contact order to expire or for the judge to dismiss the no contact order before you have any contact.
Yes, this has been a great, wonderful discussion, and I'm quite sure that we could never exhaust it over a short recording. It's technically, of course, full, legal course in college to learn about the law, to learn about what happens in these processes. So definitely thank you for joining us and having this conversation. This has been a wonderful opportunity for us to engage and educate our participants and family members who support the work of Citizens for Prison Reform. The Participatory Defense First Hub is really dedicated and committed to helping families understand the processes in which we've been talking about, so they can be a participant and not be in the dark and not understand what's going on, but to be able to be actively involved and well aware of what's going on. And this conversation definitely was helpful. So thank you, Barb.
You're welcome.
And everyone who is joining us and listening in, we thank you for listening to this webinar. This has been an opportunity for Citizens for Prison Reform to discuss the Michigan courts and the circuit court and the district court process and what's been happening and how we can better understand it to prepare ourselves should we be faced with it ourselves or have a family member that is faced with it. We hope you've learned and benefited from this webinar. If there are more questions regarding this webinar, please send them to us at info@micpr.org. That is info@micpr.org. And we will seek our best to help follow up with answering any question that you may have. Thank you all for joining us.